Senator from Oregon.
Thank you. It's my understanding that we are not in a quorum call.
The senator is correct.
Thank you. I've come to the floor to talk about the impact of the Laken Riley bill upon children here in the United States of America, and to suggest that we have a debate over several amendments designed to more appropriately treat our children that reside here in the United States so we do not end up doing significant injury to them, which I very much believe is going to be the result if we proceed without some changes. But let me start just by noting my thoughts are, as I think the thoughts of every senator, are with Laken Riley's family. Whenever there is a tragedy, no tragedy should happen, whether it's perpetuated by a citizen or is perpetuated by an immigrant. Americans should be safe in their communities, and it's absolutely clear we need comprehensive, common sense immigration reform. Here in the Senate, Democrats and Republicans worked together back in 2013 to just pass just such a bill. Enormous investment in border security 12 years ago, approved in this body by Democrats and Republicans together. That bill never got a hearing in the House of Representatives. So I hope we will, in fact, try to resurrect the spirit that inspired us 12 years ago in this coming year for comprehensive reform. This particular bill is very troubling in how it impacts children. I am troubled that a bill of such consequence and, quite frankly, legal complexity was brought to the floor without going through committee. Really, here in the Senate, the way to do responsible work on complicated, consequential bills is to have them go before committee so the committee can bring in all the experts necessary to resolve disputes and understandings about how the bill might work. From that common understanding, needed reforms can be implemented. But here on the floor of the Senate, where often only one or two of us are here at a time, there's no such consideration, and we can't bring experts to the floor here to resolve these issues. Now, my colleague from Alabama is here today, and when I propose that we consider certain amendments, I anticipate she's going to object, although I'll try to persuade her otherwise with the logic of my presentation. But I would say the core point stands, that this bill is consequential, it is complicated, and the potential impact on children is dramatic. So let's work to prevent something really awful from happening here in our country, because I know that's not the intent of my colleague. This bill, as written, requires ICE officers to detain individuals who have neither been charged nor convicted of a crime. Neither charged nor convicted. Children imprisoned without being charged or convicted of a crime. That's what this bill does. In the current system, children can be, in fact, detained, but it's at discretion on the front end and discretion on the back end to understand the whole of the circumstances. Is the individual a flight risk? Does the individual pose a risk to the community? Are we talking about an assault with a deadly weapon, or are we talking about grabbing and eating an apple while walking down the aisle of the grocery store? That discretion is obliterated in this bill. If a 5-year-old girl in either of our states, I'm from Oregon, and Britt from Alabama, gets hungry and grabs that apple, the Laken Riley Act says that young girl, if arrested, must be put into an ICE prison. Must be, without discretion. And there is no provision in the bill to get that girl out. There is no required review. This is an obliteration of everything we understand about due process. A child arrested but never charged because there was, in fact, in the end, no evidence, no conviction because since there's no evidence, there's no trial, is still sitting imprisoned without recourse in an ICE prison. This is not the America I know, and I don't believe this is the America my colleagues across the aisle want. So I come here to say, let's work together to fix this bill. That's what we're looking to do today. So, I have 3 amendments, and I will explain each of the amendments before I ask unanimous consent to set aside the pending amendment so that the amendment could in fact be debated and voted on. The first amendment excludes children from this bill. If the idea is that mandatory detention should apply to adults, then let's exclude children. Children would still be subject to potential detention that exists under the current law at the discretion. And in fact, under current law, they can be detained with discretion, even just for an arrest before they have been charged or convicted. But there's discretion involved. And I know of no case in which there has been permanent, mandatory imprisonment of a child who has only been arrested and never charged and never convicted in the entire history of the United States of America. And we're about to change that. And that is wrong. So I ask unanimous consent to set aside the pending amendment so that I can offer my amendment number 73, that there be up to 15 minutes for debate on the amendment, and that upon the use or yielding back of time, the Senate vote on the amendment without further intervening action or debate.
Is there objection?
Mr. President.
Senator from Alabama.
Reserving the right to object. Mr. President, with all due respect to my colleague from Oregon, he voted against even proceeding to this bill. Now he is attempting to force amendments onto the bill outside of the bipartisan amendment process that we are working through. And look, I get it. I understand the frustration when your caucus is working and your bill doesn't get called up to be voted on. But the truth is, we are working diligently to make sure that all voices are heard. And I also find it really interesting because for the past 4 years, under the failed Biden-Harris administration's open border policies, I have not seen one bill be brought to the floor from this side of the aisle to really focus on what's happening to children as a result of these policies. If you look at our wide open border, we've had over 468,000 unaccompanied children come across our border in the last 4 years. When you look at the numbers that HHS has put out, they admit to losing at least 85,000 children. Where has the outrage been? My colleagues and I on this side of the aisle have been diligently bringing this to the forefront time and time again, even holding our own version of a hearing because we couldn't get our Democratic colleagues to shine light on this. How dare they step out of line with Biden and Harris and their open border policy and agenda? How dare they? They should have. We did, and we will continue to make sure that we speak up for these kids. When you look at what's happening to migrant children being trafficked in many cases, from drug trafficking to sex trafficking to stories that are absolutely gut-wrenching and heartbreaking, something has to be done. And it begins with making sure that we have accountability and that we are taking criminals off our streets. And it's not just migrant children who have paid the price for the failed policies of this last administration, Mr. President. It is American children as well. Look at 12-year-old Jocelyn Nungary in Texas, who was brutally raped and murdered by two men who never should have been here. Look at Laken Riley, who last Friday would have celebrated her 23rd birthday had she still been on this earth. Had this bill been enacted, Laken Riley would still be alive. This bill is a life-saving bill. This bill protects children. We're going to continue to fight to expose the detrimental impact of the Biden-Harris open border policies, and we, on this side of the aisle, look forward to joining with those on the other side of the aisle that are willing to make common sense, targeted reforms to keep Americans safe. And Mr. President, because of that, I object.
Objection is heard.
Mr. President,
Senator from Oregon.
my colleague laid out quite a set of factors there. But let's not blur the picture. The picture is this: child came here, brought when they're 2 months old. They've been here for 12 years, they're 14. They walk out of a store with a group of children. The police officer thinks they saw something put into their pocket, arrests them. Turns out they didn't put anything in their pocket, nothing was in there, but they've been arrested. Now ICE is required to indefinitely imprison that child. That child in Alabama, who's going to be a great outstanding member of their school and of their community, sentencing that child with no charge, no conviction, no crime to prison. And we know exactly what harm that type of imprisonment does. That's what this amendment is about. I can't take on all of the other issues, but I will say last year we had a bipartisan group develop a comprehensive bill, and my colleagues across the aisle blocked it from coming to the floor. But that was last year's debate. This is a bill that has a purpose. But I don't think the purpose is to wrongly, indefinitely, mandatorily imprison innocent children. So I would ask my colleague, while you're objecting now, let's continue this conversation, because it's that important to fairness in America. And there is a legal difference of opinion currently, so I'm just going to describe that. It was sold on the House side by saying that there's a settlement called the Flores Settlement, which will continue to protect children and prevent this from happening. An innocent child, indefinitely detained, in prison, with no review process. But let's turn to the Council for Flores. The Council for Flores has put out a detailed statement. I have a copy. I understand that other lawyers may have other opinions, but these are the experts. And they say the Flores settlement does not apply to undocumented children in the community. It applies only to children detained in federal immigration custody by DHS under Customs and Border Protection, or Immigration Customs Enforcement in certain circumstances, and so on and so forth. Neither the Flores settlement nor any other existing legal protection would prevent undocumented children from being mandatorily detained by ICE under the Laken Riley Act as it is currently written. It goes on to note and explain Flores settlement is a consent decree, and law, federal law, trumps consent decrees. And it goes on to say that children, including toddlers, are not exempted from the Laken Riley Act, and that 24 states have no minimum age for prosecuting children, meaning you can be arrested at any age, even a toddler. So I will ask my colleague not, again, to consider granting consent for this amendment, but I would ask that you'll work with me to explore this topic and see if we can fix this problem to our mutual satisfaction so we don't do harm to children. If you would consider doing that.
Always work with you to talk about how we can help children. Always.
Thank you. And we are on the same hallway over in the Hart Building, and I look forward to cooperating on many topics, but this is perhaps the most important one at the moment. A second amendment that I have creates some of the flexibility that exists in current law that doesn't exist under this bill. It requires DHS to employ what's referred to as the best interest standard for the child. This is the standard that is used in virtually every single state in the foster care and child service industry. And so the amendment reads, it requires, it's nice to have very short amendments, it requires DHS to only detain children in a manner consistent with the best interest of the child that does not abrogate, modify, or replace protections for children in federal law, regulation, court orders, and decrees. In other words, preserving the flexibility that exists in current law, which means could be detained, but a judge can consider the totality of the circumstances, the level of the crime, whether or not there is a flight risk, whether or not there is a potential harm to the community. The best interest standard seems like an appropriate thing to apply when we are in fact collectively striving for the best interest of the children. So I ask unanimous consent to set aside the pending amendment so that I may offer up amendment number 72, that there be up to 15 minutes for debate on the amendment, and that upon the use or yielding back of time, the Senate vote on the amendment without further intervening action or debate.
Is there objection?
Mr. President,
Senator from Alabama.
reserving my right to object. We have repeatedly confirmed with ICE that all existing consent decrees would continue to apply. This amendment addresses something the bill doesn't do. And as I've said, the Laken Riley Act would protect kids. It's bipartisan, it's targeted, and it's common sense. That's why we must keep it that way. I object.
Objection is heard.
Thank you, Mr. President.
Senator from Oregon.
I do disagree with my colleague because this bill eliminates the flexibility in the current system to consider the totality of the circumstances, and restoring the best interest standard that every state is intimately familiar with is remedying the lack of flexibility in the bill as it is written. But again, we will continue this conversation. I view coming to the floor and having this dialogue as a kind of a way for us to do something that's too rare, way too rare here in the Senate. We rarely have these type of conversations in front of the American people, and I think it's important we have them, especially when there's some value that maybe we share the same value but have different interpretations on how that value will be impacted. I'm sure we share the same value on trying not to do kids wrong, and that's why I value this dialogue with my colleague and hope it will lead to the opportunity to resolve these issues. So I have a third amendment. And the third amendment is related to another aspect of the way children are affected, including American citizen children. Imagine the parent who goes to work, who's accused, I don't know, of stealing a piece of a tool out of the factory. And so he's arrested, or she's arrested. And now, under this bill, that adult has to be locked up. No flexibility on the front end, even though it turns out they did not steal the tool. They had nothing in their bag they had with them. The officer thought they did, they didn't. They never get charged. They never get convicted because there's no trial because they're not charged. But that child who has maybe 1, 2, 3, 4 American citizen children at home waiting for them, They come home from school, no parent comes home. They have to be locked up under this bill. So we're not just talking about an impact in this bill on immigrant children. We're talking about an impact on citizen children. Now, I care about both, but I just want to note that there's been a conversation about this bill as if it only affects immigrants. No, it affects American citizens too. It affects the spouses who might be American citizens. It certainly affects the children who are likely American citizens. So this amendment says that if an adult with children under 17 is subject to the mandatory detention that currently has no end, no back end to it, has no ability to appeal, it's permanent detention, permanent imprisonment, that if they have children at home, after 30 days, there would be a court proceeding to consider whether or not the conditions should exist for release after the normal set of issues are considered, such as, is this person a danger to the community? Is this person a flight risk? Can they be released with bail? The same things we have now, because back at that home are a bunch of children, maybe non-citizen children, maybe citizen children, but a bunch of children who are going, my parent never came home. I'm not just a latchkey kid with the parent coming home at 10 p.m. because that's when their shift ends. I'm a kid who doesn't know what the hell to do now, and my life has been shattered. So this would create the opportunity for that flexibility that exists in current law after 30 days of mandatory detention. I think it's an appropriate way to address the potential for impact that I'm sure no one intended in writing this bill, which was to leave a bunch of children back in a home with no parent and no support. I ask unanimous consent to set aside the pending amendment so that I can offer amendment number 71, that there be up to 15 minutes for debate on the amendment, and that upon the use or yielding back of time, the Senate vote on the amendment without further intervening action or debate.
Is there objection?
Mr. President,
Senator from Alabama.
reserving the right to object. Mr. President, we have heard a lot of things that are untruthful about this bill today. First off, no one's due process is taken with regards to their immigration proceeding that may be moving and the ability to see the criminal proceeding through to the end. At the end of the day, we have to make a decision, and that's the decision that is in front of my colleagues right now. Are we going to protect open border policies, or are we going to protect kids? I mean, we are seeing, just even in this conversation about carve-outs and whatnot, you've got teen migrant gangs running rampant in New York City, allegedly running theft rings with children as young as 11. Think about what you do when you think about each one of these things we've discussed today. If you were to carve out a certain kid or a certain age, you don't make that kid safer. You make them a greater target for the drug cartels, for the people looking to move crime. We have to make sure that we are taking a common sense approach to this. And at the end of the day, if you don't commit a crime, you're going to be good. And so I am here today to say it is time to pass the Laken Riley Act. It is past time to do that. Having a common sense targeted approach that does not fix everything. I hear my colleagues' frustration with regards to regular order of last year. I would like to echo that. You think about what we're dealing with right now. Mr. President, we have had over 11 million people come across the border under the Biden-Harris administration. Some people say that number is much higher. There's at least 2 million that came across the border that we don't know who they are, where they're going, or what their intentions are. You look at the non-detained docket we have here in our country, 7.8 million. You look at those who have been given their due process, 1.4 million. have been issued their final orders of removal, meaning they've been given their due process, and we have said, you have no legal right to be here. We've got to do better at tackling every bit of that, and doing better starts today. We're not only going to do right by Laken Riley and her legacy, we're going to do right by the children of this country, making it safer and more secure. It's exactly what this bill does. It's a bipartisan piece of legislation, and we must keep it strong and keep it that way. So on that, Mr. President, I object.
The objection is heard. Senator from Oregon.
I was hoping those last two words were I object, but this is an important issue that's been raised, and we need to look carefully because there's no intention to leave a house full of children home alone when the parent poses no flight risk, has committed no crime, poses no risk to the community, and those children are being harmed. In fact, I do take factual dispute with a few of my colleagues' points. So you know that no due process has been taken. When you eliminate the discretion on the front end, you change due process. A judge can no longer say, this person has no flight risk, no risk to the community, has children at home, will put a high bond, they'll absolutely show up, we know who their relatives are, and that will be best because justice, if the person is subsequently charged, they'll be there for trial. That due process is stripped away on the front end. There is due process in existence now on the back end, where a person can challenge their detention and whether or not they should be there. In fact, during the previous Trump administration, there were children who were released with such challenges. But that's taken away. So yes, due process is dramatically changed with a huge impact on children. And my colleague mentioned that we don't want children to be a target for gangs. Amen to that. Who is more of a target for gangs than children left alone in the home because their parent has been unjustly imprisoned? That it is exactly the opposite of what my colleague wants to achieve. So I know this conversation will continue, at least I hope it will. We are now under a filed cloture motion, which means the majority intends to close debate, probably on Monday. And yet, one Democratic amendment has been heard. One. The majority leader has said he wants to do things differently, that he wants there to be an amendment process. The amendment process I saw when I first came to the Senate consisted of standing up and saying, I have a relevant germane amendment. I'm asking for the existing amendment to be set aside so that mine can be brought up, which puts it in a queue for consideration. Then people could study it, and then you go to a whole series of votes on all those things that are in that queue. We did this on Dodd-Frank. We did this on Obamacare. I think we should do it here because the consequences are high. But if that can't be done, then I would ask my colleague who has worked so hard on this particular bill to take a look at whether the Republican side will agree to hear these amendments and vote on them. They may be voted down, but I think they're important. I think it's extremely important that kids not be wrapped up in this. They can currently be detained, but it's with discretion of the circumstances. I think it's particularly important that we have a standard for children in terms of their best interest. I think it's particularly important that we have a way after a few weeks to have some look at whether children have been left home alone and if the circumstances are appropriate and there's no flight risk, the circumstances are appropriate, there's no community risk to help address that situation, or we are harming children this was never meant to harm. So I ask for my Republican colleagues to consider providing an opportunity because it takes 100%. Every single senator has to agree to hear an amendment. We used to have the Senate Code. And the Senate Code was, I want to object to your amendment, you don't object to mine. They're on the topic before us. These are on the topic before us. These are not some crazy thing. These are addressing core due process issues that affect children. So I would ask that at least they get some discussion for the possibility of consideration. Thank you to my colleague from Alabama for coming and hearing me out, as well as, I'm not really thanking you for objecting, but I am thanking you in the spirit in which I think you want to do the right thing, and I'll keep striving to convince you that the right thing here is we should debate these amendments and vote on them. Thank you, Mr. President.